walk through the fallout of all this, I want to start with that request for a federal investigation, because to me, the criminal probe, potential criminal probe tied to all this is more significant than the request for a new trial. I think Alec Murdaugh's going to get a new trial, because if even half of what is alleged in this complaint from Harpootlian and Griffin is half true, Alec Murdaugh will not only get a new trial, he will deserve a new trial.
So I am here with Mandy Powers-Norrell, who is one of my favorite attorneys in South Carolina. She's a former state representative, former candidate for lieutenant governor, and one of those lawyers I know I can go to get a unbiased, fair, and intelligent perspective on my legal questions.
When I, read the filings by the defense, first I tried to guess what it might be. Are they going to say a juror was looking at social media, or somebody, from the outside influenced a juror? And then you would have a standard of review of harmless error, and the question would be, did it change the ultimate outcome of the trial? That's a very high standard. And that's why most criminal appeals are not successful, because you can't show, the burden of proof is on the defense to show that it would have changed the outcome. And you really can't show that it would have changed the outcome very often. And so they would have to lower the burden and change the standard of review. And one of the ways to do that is if the outside of the jury communication came from a court official, which changed that standard of review from did it change the result to could it have changed the result? What a difference that is.
Right.
And
so were you as surprised by the allegations as I was?
Knowing the stakes, I was not very surprised by the allegations, because if they're going to get a new trial, the best way to approach that is to find any communications from court officials and then turn, and say that they were designed to or could have influenced the outcome. That's their best shot. And, if I'm on the defense, I'm grabbing that book as soon as it comes out and saying, let me see if I can get a Rimmer hearing out of this. And the best excerpt they got was that she had talked to jurors with her eyes. She's like, they knew and I knew, and we told each other with our eyes that he was guilty. So that in and of itself could be interpreted by some courts to be an admission of communication about guilt from a member of court staff. I don't know that jurors took it that way, because we don't have any affidavits from a juror saying she told me with her eyes that he was guilty. So for it to be communication, you have to have a sending and a receiving. So I think that might, if I'm the state, I'm saying, well, that fails. That's not a communication. So she can't admit to a communication that wasn't received.
Mm-hmm. We kind of lived a little bit on the edge in that particular chapter, because I thought it was so important. Becky did lock eyes with the jury. It's in the book, the jurors, that it's just one of those women's intuition, if that's a fair thing to say, that she just locked eyes with many different people who were there. And it was just one of those, I wasn't there, so I don't know. It's just kind of like you just knew, kind of a look. But it wasn't conveyed, as far as I know, it was not conveyed orally.
But when you look at all the allegations in the affidavits, very few of them relate to communication by a court official. And that's the only one that has that lower standard that could, I think, actually get them a new trial. The other ones have a standard that's so high, I don't think they could overcome it.
Slow down.
This is State versus Richard Alexander Murdaugh. Your Honor is aware he's been indicted in a slew of state grand jury charges, and I'm happy to read those numbers into the record. They are extensive. We have 2021 GS 4727 in Orangeburg County, containing a number of white-collar counts. 2021 GS 4728 in Bamberg County. These were indicted in the state grand jury in November of 2021. We have 2021 GS 4729 in Allendale County, also indicted in November 21. 2021 GS 4730 in Beaufort County, also indicted in November 2021. 2021 GS 4731 in Carlton County, also indicted in November of 2021. 2021 GS 4732 in Hampton County, indicted in December 2021. 2021 GS 4733 in Hampton County, also indicted in December 21. 2021 GS 4734 in Hampton County, also indicted in December 21. 2021 GS 4735 in Beaufort County, indicted in December 21. 2021 GS 4736 in Hampton County, also indicted in December 21. 2021 GS 4737 in Hampton County, indicted by the state grand jury in December 21. 2021 GS 4738 in Carlton County, that's indicted in December 2021. 2021 GS 4729 was a superseding in Allendale County in January 2022. 2022 GS 4701 in Hampton County in January 2022. 2022 GS 4702 in Hampton County, that's January 22 was when it was indicted. 2022 GS 4703 in Allendale County in January 22. 2021 GS 4727 superseding in March of 22 in Orangeburg County. 2021 GS 4730 superseding in Beaufort County in March of 2022. 2022 GS 4701 in Hampton County in April. 2022 GS 4702 in Hampton County in April. 2022 GS 4703 is superseding in Allendale County in April of 2022. 2022 GS 4710 in Carlton County in June of 2022. 2022 GS 4723 in Hampton County in August of 2022. 22 GS 4724 in Carlton County in August of 2022. Finally, our last two, 2022 GS 4734 in Hampton in December of 2022, and 2023 GS 4703 in Carlton County, indicted in April of 23. Your Honor, the state grand jury indictments that I've just listed against Alex Murdaugh represent 101 total charges for an alleged loss of almost $8.8 million.
But more importantly, maybe this is the toughest thing I have to say, and that is this. This case was finished 6 months ago. It clearly, I don't think anyone disputes, has had more publicity than any case in the history of this state, and maybe the country. On national television every day for 6 weeks, the motions motions hearings were covered, and they're here again today. It has been podcasted, blogged. We've got podcasters out there who are ripping their 15 minutes and hanging by their fingernails, wanting more of their 15 minutes of fame, and continue to talk about this.
Harpootlian was the one who did a press conference. He's the one that went out before the microphones. So he's out there poisoning the jury pool. That's what he was trying to do with a press conference on the State House grounds in front of the Court of Appeals. That was his way of poisoning the jury pool. So everybody here has skin in the game. Harpootlian was saying podcasters are out there. They're talking about it all the time. His partner, Jim Griffin, has a podcast, started it 4 weeks ago.
I mean, look at Harpootlian this week at the doggone Crime Con. He's selling Alex Murdaugh at Crime Con. I mean, go figure.
And Your Honor, to try this case in less than a year after the verdict came in the other case, don't we need to let it calm down a little bit? Where are you going to get a jury? Mars? I mean, this is just another attempt to get more publicity, to make this another national case. And, Your Honor, I'm offended. This is another effort at creating a national spectacle. As you know, as a prosecutor, I'm bewildered by this. I'm certainly they can do it, but why? Why?
Representing the Satterfield family, and had this to say after court today. I don't think he's going to plead guilty to those state court crimes, because then there'll be 3 convictions, because he's pleading guilty next week to the federal charge. Now he's going to plead guilty to the state charge. That's 3 convictions. It could be 3 strikes you're out. Don't know if the state's going to count the federal court guilty plea he's going to make next week, but I would be really shocked if that trial goes forward. I would expect that Dick Harpootlian's going to break a leg, get a flat tire, get kidnapped to Bulgaria. I'm not sure that trial's going to go forward, but it is on the books. The jurors are, they're nervous. They gave seven weeks of their life. They serve the public. They serve the jury system and the justice system for $15 a day. And then some lawyer gets behind a microphone and suggests that they need to lawyer up. I think they're scared, not because they've done anything wrong, but they don't want any type of notoriety. They want to go about their lives, and this just pulls them back in again, kind of like Al Pacino in Godfather 3. We are going to be speaking with SLED over the next couple days.
Let's get into it here. On September 5th, appellant Murdaugh moved pursuant to Rule 29B, SCR Crim P. Scrimp. In my brain, that's how that goes. Scrimp. South Carolina Rules of Criminal Procedure is probably what that stands for.
To suspend his appeal and grant leave to file a motion for a new trial based on a blend of mixed allegations broadly directed at the Colleton County Clerk of Court, Rebecca Hill. Respondent would show as follows. A motion for new trial based on after discovered evidence may not be made while the case is on appeal unless the appellate court, upon motion, has suspended the appeal and granted leave to make the motion, which they did try to do, Murdaugh's team. There can be no doubt that motions of this sort should be received with the utmost caution because, as it is said by a learned judge, there are but few cases tried in which something new may not be hunted up, and also because it tends to perjury, meaning to create situations where people can lie after the fact and change the facts, which maybe is going to be alleged in this case. And therefore, we can't have that happen. You only get one bite at the apple type of deal.
State versus Matthias from 1934, quoting State versus David from 1881. The prosecution's like, hey, Poot, we found some cases from your day.
It would have a mischievous tendency, after all the evidence on the part of the state had been fully disclosed, to allow one with his life in danger an opportunity by the assistance of Confederates to procure unprincipled witnesses to contradict the evidence on the part of the state and thereby defeat the ends of justice.
Quoting State by Harding, 1800. Oh, we've gone back. We've gone back beyond 1881 to 1800, full stop. They're like, we're going back to our histories. If Poot wants to grandstand, we're going back to the history books, Poot. Back to the 1800s, back to the inception of our justice system.
So basically what they're saying is part of this protection is so that we don't have situations where a defendant pays off a witness or pays off a juror after they've already made the decision. Here's $1 million, flip your vote, tell them that you were going to vote not guilty, but somebody, pressured you into voting guilty. We do not want that in our justice system. May sound obvious, but it's worth saying and worth mentioning.
I am very interested to see if the state argues that there is a different standard of review. This is all we've heard from is the defense at this point. And so the state may argue, no, we are at the did it change the result standard of review, which I don't think they get a new trial if that's the standard of review. I want to hear an argument that that's the one we apply as opposed to the one that seems to me to be clearly the one to apply.
To prevail on his request to suspend the appeal and have the matter remanded to the circuit court to proceed on a motion for a new trial based on after discovered evidence, appellant must show 1, the evidence in question is such as will probably change the results if a new trial is granted. So there's a difference here in the standard. The AG's office is trying to argue that it has to change the results or probably change the results. Murdaugh's team says no, because it's jury tampering by the court clerk. And if that exists at all, that's enough to to cast a shadow of doubt over this verdict. The way I read the case law they presented, I think that is correct. Now, this motion made by the AG is also correct in that a motion for new trial based on new evidence, that new evidence usually does have to cast doubt on the verdict.
It may well be the suspension of the appeal and remand for an evidentiary hearing will be necessary to properly resolve some of the serious claims raised by Murdaugh in the motion he intends to file. I don't disagree.
There's another answer to a question we had off the top. Do they think we should have an evidentiary hearing? Do we think this should go back to the circuit court and pause the appeal? Sounds like the AG's office agrees, or at least is not fighting too hard, that we should have an evidentiary hearing in this case.
We may need an evidentiary hearing. I just want one. That is where I'm leaning. That is just based on one. I want to see this happen.
I think we need it personally. I mean, as far as the public is concerned, this does not look good. We need to make sure things were done the right way for the worst of us, so they'll be done the right way for the best of us.
But procedure needs to be followed, right? We need to go through the due process of the whole thing.
As of now, the investigation, for better or worse, being led by the South Carolina State Law Enforcement Division. Now, we first reported on that investigation the night after these bombshell allegations were dropped, and SLED confirmed that they were leading that investigation the next day. The question is, should they? And I've had a lot of talks with a lot of people about that, because anyone who doesn't believe SLED has a vested interest in the conviction of Alex Murdaugh being upheld, again, I don't know what planet you're on. I don't know what story you've been watching. They clearly do. And while I've heard from my sources at SLED that they are only interested in upholding justice, I think we've got to look at that with an ocean of salt.
Objective investigation by SLED, footnote 1. Agents utilized by SLED for this purpose are separate and distinct from those who have otherwise investigated appellant's numerous alleged crimes. Is there anyone left in SLED that hasn't investigated Murdaugh at this point? How did you find anybody? Between all the financial crimes and the murder case, is there anyone left on SLED that can do that? Is there like one person?
Objective investigation by SLED remains ongoing, but the inquiry has already revealed significant factual disputes as to the claims in appellant's motion. So there's another little zinger. Objective investigation by SLED, I think Murdaugh's team would take issue with that, remains ongoing. But already in the very beginning, right off the jump, there are significant factual disputes as to the claims in appellant's motion. So that means they're not necessarily agreeing that even what Murdaugh's team has put in their motion as fact is true. And there's going to be some discrepancies. And again, an evidentiary hearing before the judge could solve these problems.
This is why we're going to probably need an evidentiary hearing.
If no credible evidence can be found to support the claims by the appellant, the state will be prepared to argue against the motion before the Honorable Clifton B. Newman on remand. So what's interesting here, it says, if no credible evidence can be found to support Murdaugh's claims, then the state will be prepared to argue against it. But you would say the inverse of that would also be true. If they do find credible evidence, if they do talk to these jurors who said that they were influenced or talked to or felt like the clerk felt a certain way and therefore subconsciously it made them feel that way, if they do find credible evidence of that, it sounds like maybe they won't even argue against a new trial. I think we know which side their investigation is going to come down on, but interesting. And that's the way a prosecutor should act. If they find problems in the case, that it was not done right, his due process was trampled on, they should not argue against a new trial. And so I give them props for putting that in the motion.
However, at present, appellant's request for remand is procedurally defective. Yeah, you got to do it right.
Appellant's counsels have, however, made multiple statements to various media outlets indicating they were potentially aware of an issue with the jury at or about the time of trial.
In a press conference on the steps of this court on September 5th, counsel Harpootlian, responding to a question as to whether they saw the alleged conduct during the jury view or found out about it after the fact, replies, "I think we observed it. I was there. I watched it." Footnote 2. And then it has the link.
When the fourth person was pulled away at Moselle, did you guys see that or did you find out after the fact?
Well, I think we observed it. We did. No, I was there.
Oh, yeah, you're right.
Yeah. I was there. I watched it.
Later at that same press conference, when a reporter asked if they approached the jurors or vice versa, Griffin replied, "Immediately in the aftermath of the verdict, we received information that we need to look into what happened in the jury room." In one interview with Good Morning America on September 6th, counsel Griffin states that soon after the trial, actually as soon as the verdict was rendered, we had gotten some information from folks in the courtroom that there was something untoward that had happened in the jury room. We didn't know exactly what, and we went on a campaign to find out what. Accordingly, the state is compelled to move to dismiss due to the procedural defect. The state would request the court grant appellant a leave of 10 days to correct the procedural defect.
In the event appellant properly files, remand may be necessary for the trial judge, the Honorable Clifton B. Newman, to consider the credibility of the claims in light of the significant factual disputes which undermine the credibility of the claims. But I think we did get a few answers here.
I want to know, did Dick make the first contact or did investigators?
Dick Harpootlian did knock on one door. No, and it had to have been an investigator, because we don't want to also become our own witnesses. We don't want that. Why we send the investigators.
But Dick said they did it. Dick said it was Jim and him that were driving down dirt roads. They remember in his Mercedes.
At their press conference, they never said it was investigators at the press conference. They said it was them. That they, like Eric just said, that they were driving down the road.
Johnny, you and I would have never done that. Amy, you and I would have never driven to a juror's house like that. We'd have an investigator first.
Absolutely. They're so fancy. They have an investigator go out there. That's exactly what you do. You send an investigator out to make sure that the integrity of the system happened. And
you don't want to be a witness. John is 100% right.
Yeah, you don't want to be your own witness. They don't want to be called to testify at this hearing.
We're handling an appeal and we're trying to delve into everything. And you wrote an email to the judge, yes, right? Sir. Okay. And what we'd like to figure out is what happened to cause you to do that. You worked with, right? And she said to you what?
She was talking about the trial, and she said that her landlord had came over and she had the refrigerator replacement. And her landlord came over and she was, telling her that she's a jury.
This juror worked on a monkey farm in the Low Country, and she drove Judge Newman bananas one weekend, pun intended.
That was my line.
Very good.
And she thinks Alex is, not guilty or isn't guilty of it. And she does.
Or did she say that they hadn't proved him guilty?
She told me that she said that she thought Alex was not guilty.
Okay.
And I felt, not even though that she's saying that, but even though she said, I feel Alex is guilty or isn't guilty, I feel as a juror, you wasn't supposed to be telling nobody you're a juror.
Right. Okay.
And I just felt
we're not being critical of that.
Yeah.
Did you ever talk to the court? Becky?
No, I did not.
Did you talk to any SLED agents? Anybody interview you?
No. Nobody's talked to me other than...
The only question I'd ask is, after you sent the email, did somebody contact you to find out who these people were and so they could follow up with them?
No, nobody did.
So
I never once indicated where I worked. I never once indicated, who she was. and I still got the email.
No, we have email.
Yeah, I mean, nobody contacted me. I have no reason to lie.
What we may want to do is get an affidavit from you that no one ever contacted you and questioned you. Can you do that? We're going to be back in Sunday. Will you be around?
Yeah, I'll be out in about 10 minutes.
Okay, all the affidavit is going to say is you sent this email and no one ever contacted you and questioned you about who it was or anything specific. Right? Okay, thank you.
All those books are coming. It's just a matter of time. It just looks like yours hit the shelves first, and you're now catching some heat on that. But
when you've been in the media world as long as I know, you live by deadline and you live by timeliness. Right. And if you wait a year, you probably miss your window. And we hustled faster than anyone thought we could. And our whole goal when we started seriously talking about it, Chris, in late April, was we knew the boat trial was coming.
Yep.
And we just figured, let's do everything that we can to have to put out what we have to put out before this next wave takes over. And then, of course, you hustle. The book comes out, exhale, and then, they settled.
Right. And I don't know. I know the public understands most of that, but as Karen says, when the story has legs, it's moving.